A very good afternoon to Mr. Justin. This is my presentation for Assignment 2 Media Law. And for now, the Assignment 2 is based on media freedom, so I will share my slides. So the laws that I chose, both of them is Internal Security Act, aka SOSMA, and also Sedition Act. So Internal Security Act 1948 is actually enacted during 1960, and it was like 3 years after the Malaysia independence to cope with the communist threat. The sanction for it is detention without trial and legal counsel for indefinite period of time. So even though it was replaced with SOSMA, that you can detain someone for 28 days, because based on the case like Maria Chin Abdullah, she was detained for 28 days, and at this moment she was denied of bail or trial. So no one knows her well-being and her condition of safety. So it wasn't consistent with the fundamental human rights. Under the Article 149 of the Federal Constitution, it is all the acts that is relevant to Malaysia security, like anyone acting in the manner prejudicial to the security of Malaysia, they will be held in action. And the next act was Sedition Act 1960. Sedition Act is basically the actions that contains any seditious tendencies, and it was amended recently in 2015. It was strengthened. Article 10(4) states that any questions sensitive to Malaysian politics cannot be asked, and media freedom. So the first changes I would suggest, set a benchmark, like the issues like any manner prejudicial to the security of Malaysia. It is very broad and ambiguous. Like the security offences itself, it's very wide. There would be like a guideline or anything that can, like words or vocabulary you cannot use. Second suggestion is quite similar to the first suggestion, that you have to narrow the grounds of actions. Like, so I suggest instead of warrant, maybe if you arrest that person at the spot, you need to have a basis of evidence, like a witness or anything solid. Like, it's just not because of their political belief that you arrested them. So the next changes I propose to Sedition Act is that the vocabulary for seditious tendency is also quite wide and broad. Like, you don't know what is considered seditious, because it could be likely seditious, or if the government thinks you are saying something seditious, they could arrest you. Yes. So in this case, if we need to stop strengthening the Sedition Act, make it more viable towards media freedom. Suggestion 2 is the same thing, like granting of bail or trial, in this case either one, just to maintain their personal safety. For that, I would like to propose a quote from Thomas Jefferson: "Our liberty depends on the freedom of the press, and that cannot be limited without being lost." Thank you for listening to my presentation.
Hi guys, I'm Joan. Today I'm going to talk about the printing presses and the Publishing Act 1984. This act was created in the 1984. According to the Article 3 of the act, requires a government license before anyone can begin printing. Under the Article 5 of the act, anyone who exports, publishes, or sells without the permission will be fined and sentenced to the fixed term imprisonment. Actually, many of the medium believe this is incorrect, because it will restrict the free speech of the media, and they will be controlled by the government. Once there was a media organization to export the Prime Minister's finance issues, so the government controls the media organizations. So the the media organization has disappeared from the people's views. Finally, all of the media organization think this is very dangerous and the protest. So we will give the some suggestion for this act. So this is our first suggestion. Change of the government license under the Section 3 of the Act. And the second suggestion is set up the council controlled by the people, the media, and the government, so that a license can be issued. Actually, this is our most important point. Oh, yeah. So let's pass to the next people.
Hi, I'm Leah. For this part, I chose Communications and Multimedia Act 1998, which I will call it CMA later. It's an act for restricting and regulating the online communication and multimedia industries in Malaysia. Under its Section 53, the MCMC provides directions to deal with the situation that penalties imposed on license for non-compliance under provisions of the CMA. Besides, according to the Section 233, people who use network application facilities or service to create or spread any offensive state with intentions of harassment would be found guilty. So in terms of their proposed changes, in order to deter the unfettered online media statement and raise awareness of abiding by the network order and regulations, the Section 53 was considered to increase its intensity of punishment with an extensive increase in penalties against the license for non-compliance. For Section 233, it has been widely criticized as being too general and broad, which would be simply used against almost anyone and cause various public controversy. Hence, the scope of offense should be tightened by requiring higher standards for the threshold of prosecution than the current ones. Moreover, before any comment would be deemed as offensive, the section should introduce the necessity of the proof of intention so as to reduce the possibility of arbitrary prosecution. For the Official Secret Act 1972, I will call this OSA later. It's an act provides that anything at all can be declared as official secret. It's also a replacement for the Malay State of Official Secret Ordinance 1950 and was modified from the British OSA 1911 and 1920. The definition for OSA is described under Section 2 of the Act, while Section 2B provides that the document can be declared official by the Minister or Chief Minister of a state. For its proposed changes, similar to Internal Security Act, this act should be repealed and impose much lenient restrictions, especially towards journalists and subsequently the public, as the act might interfere with balanced reporting for editorial independence. It would be reasonable to further define the definition of official secret or relevant terms on media-related news content. The use of OSA threatens media freedom as it creates barriers and hinders with the rights to information. Therefore, one of the amendments necessary to the OSA would be any document classified as official secret, once it was certified, should include requirement in relation to national security, in the international relations or defense.